Good morning, everyone, and welcome to our September webinar. Now, the eagle-eyed amongst you might be thinking that this looks a little bit different to yesterday's webinar. You are absolutely right. I had a few technical gremlins and I wasn't happy with the recording, so I have decided to rerun, and I will be sending the link out and posting it on YouTube and also on social media as well. So this is take two, but welcome to our webinar. We had a month off in August, so it's great to be back with you all. Fantastic to see so many new people who have found our webinar. And it's great to be building that HR and leadership community. So thank you very much. Just for those who are new to our webinars, we run them monthly. We do have a summer break. And the idea is that they are a chance for you to listen to case law updates, legislation updates. We also get individuals to join as well to bring you some different voices and some different topics and ideas. So we've covered apprenticeships, we've covered menopause, we've covered giving fearless feedback. So it really is an opportunity to hear something new. If you haven't checked out our YouTube channel, then please do so, because all of our previous webinars are on there for you to watch on demand. So I'm going to be with you for the next 40 to 45 minutes. And as I said, running a case law update webinar. And I picked a selection of cases. Obviously, there are lots of cases that are being reported. But really, there are some common themes, I think, within the cases, which are particularly around employers and particular business managers making assumptions about what individuals can and cannot do, particularly around those that area of protected characteristics. So we'll be looking at some discrimination cases. Also looking at process and knowing how important it is to follow a fair process, and also what the consequences can be if that fair process is not followed. And also looking at cases where, you know, the devil really is in the detail. So there are some themes despite the different topics. And for those who don't know Boys Turner, if you're new you've only just found our webinars and just heard about us, then we are a full service commercial law firm based in the Thames Valley, but we service clients across the UK, across Europe, and globally as well. And in the employment team, we assist employer clients with High Court and Employment Tribunal litigation. We also assist clients with the day-to-day HR support, so disciplinaries, grievances, settlement agreements, redundancies, as well as having a thriving business immigration team. So if you want to recruit from abroad or to move your people around globally, then do speak to us. And then we have the HR training team, which I head up. And for those who don't know me, I'm Emma O'Connor. I'm a legal director in the employment team, and I also head up our HR training academy, where we run, we devise, we deliver HR training courses, manager training courses, legal courses, as well as soft skills courses as well. So we really are a one-stop shop when it comes to all things training. So get involved. As part of the training, I have been doing a lot of manager training recently. So going into businesses and talking to managers about how they manage employee relations issues, but within the legal framework. So we're talking about, you know, managing those processes, managing absences, and also how we can be more of an inclusive leader. So looking at the Equality Act 2010. And what I thought would be helpful is that I recognise that there are a number of businesses that maybe don't have a large manager population, or who want to have a look at what manager training might look like before perhaps rolling out a programme to their whole workforce. Or again, it might be that HR are just curious to see what manager training is all about. So I am giving managers, leaders and HR the opportunity to come and join my Manager Masterclass on the 23rd of November. It is going to be in person. It's going to be in our Reading office. 1 day training. Come along, meet other professionals, share experiences. As I said, we'll be looking at those manager training opportunities. So we're really looking at those areas where managers can really get involved and make a difference, and where they can be investigators or disciplining managers, what that might look like. So come along if you're interested. If you want to find out more, then get in touch with me and I can tell you a little bit more about the case. But really looking forward to seeing as many of you as I can on that 23rd. So again, classroom style, case studies, discussions, really to kind of make it as interactive as we can. If you want to get in touch, if you've got any questions that you have, or if you want to find out more about manager and HR training, or indeed the manager masterclass, then there are my details, and I look forward to hearing from you. So let's make a start. So the first case that we are going to look at is Mrs. Linsky versus Direct Line Insurance Services. Now, this case involves disability discrimination, amongst other things, but disability in relation to symptoms of menopause. Now, as many of you will be aware, there was some pressure on the government to expand the number of protected characteristics under the Equality Act to include menopause discrimination. So menopause being one of the protected characteristics as set out in the Act. Now, government decided not to do that. Their reasoning was that there was already sufficient protection within the protected characteristics already. So the relevant protected characteristics there would be sex discrimination, age discrimination, but I would just point out that menopause happens to a woman at any stage and not necessarily to a woman of a certain age. And as well, the symptoms of menopause can fall within the definition of disability, again, within the Equality Act. So when you're looking at whether symptoms of menopause do fall within the definition, then you're looking at those physical and mental impairments which are substantial, which means that the symptoms will last for 12 months or pockets which will add up to 12 months, and they have a negative impact on a person's ability to carry out normal day-to-day activities. So that would be the definition within the Equality Act. So what happened in Mrs. Linsky's case? Well, Mrs. Linsky worked as a telesales consultant for Direct Line, and she began to suffer symptoms of menopause, and she went to her GP and was given some medication, was prescribed medication for her symptoms, and she told her employer what those symptoms were, so she was open with them. However, something happened at work. There was an issue, there was a complaint made about her in terms of a telephone call that she'd had with a customer, and they had complained, and it was decided that Mrs. Linsky should move to another team, still answering calls, but it would be less pressured and less demanding. And that team also, that role also accompanied less pay as well than her current role. But by all intents and purposes, that was all agreed, and both the employer and employee were happy with that decision. She had a new manager within the new team. And what then happens is that Mrs. Linsky asks for some support from her employer. So she asked if she could maybe rejig the number of calls she has, and also look to have slightly longer in between calls. She's also seen by occupational health, who recommends some training to her, some retraining for her, but the employer refuses to do that, they say, because of budget. There are then issues of performance which are raised by her manager, and Mrs. Linsky is asking for support, asking for help, but her employer, in particular the line manager, is refusing to accept that there is any underlying condition which is impacting upon her ability to undertake her job. And actually she is given a warning as well. So employer and employer part company, and the employee brings claims for sex discrimination, unfair dismissal, and also disability discrimination as well. And the part about the disability discrimination claim is that not only does she argue that she's been treated less favourably because she is disabled, but also that her employer has failed to make reasonable adjustments. Now, that is a separate claim within the Equality Act, where you have a disabled employee or a disabled worker, And it's thinking about what changes can you make to that person's job when they are disabled to allow them to fully participate within the workplace. And that's the duty to make reasonable adjustments. And as you can see, the claimant here was successful in her claim, and she was awarded £23,000 for injury to feelings, as well as some money there for aggravated damages. So again, we can see their employers, and in particular line managers, not really engaging in processes, not really offering that support that an employer should be offering. And in fact, it transpired sort of during the evidence that the manager had even requested that the individual's sick pay be stopped. So to stop Mrs. Linsky's sick pay, to encourage her back to work. So again, perhaps not the most constructive of conversations that could have been had. And, Mrs. Linsky felt that there was no other option but to resign from her employment. So some lessons learned there, particularly around awareness, getting proper medical advice, support from occupational health, which the employer seems to have done, but then not followed up on the recommendations. So some real practice points there as well. And I think, about raising awareness more generally about disabilities, mental and physical impairments, but also around menopause and what those symptoms might be, because everyone's symptoms will be different. So it's about having that awareness and also making sure that employees are able to raise concerns with their employers and knowing that their concerns will be listened to. So that's really important as well. The next case is Mezem versus Bradford Management Services and Another. And I will talk about the and another later on. But those who follow me on LinkedIn know that I occasionally post cases where I'm really left scratching my head, as well as looking at my calendar and thinking, what year are we actually in? And I think Mezem is another example of that case where individual worked as an HR executive, again, by all accounts, well liked, well respected within the organization, good relationships with her managers. And then she announced that she's pregnant. And then things seem to change. Managers, her boss not speaking to her when he does, very angry, shouting at her. Taken her HR duties are then taken away, and she's made to go and work in the factory. To do physical work in the warehouse. And Mrs. Mezem becomes very fatigued, becomes unwell, and she goes off on sick leave. I should also point out that her employer refused to pay her sick pay as well. Whilst Ms. Mezem was on sick leave, her employer contacted her out of the blue and told her that she had to attend work because she needed to come to an emergency investigation meeting. So no details, nothing at all, just you have to come in for an investigation meeting. Now, Ms. Mezem said, well, no, because I am on sick leave and I am unable to attend a meeting with you. And her employers said, well, that's fine, but we're going to trigger your maternity leave. So they started her maternity leave because she said she was unwell. While she was on, after she'd given birth, so 2 months after she had given birth to her baby, the employer again contacted her and told her that she had to come to, again, a disciplinary investigation meeting to talk about serious allegations. And again, Miss Mezem said, well, I had a baby 2 months ago, so it's not really convenient for me to come in and talk about a disciplinary investigation and what's going on. Again, no details, no third process, etc. What had actually transpired is that Ms. Mezem was being accused of stealing food from the canteen. And when this all came to light, she explained to her employer that in actual fact, one of the managers, because she had to work late and she wasn't able to take an effective lunch break, had told her that she could take some food for the canteen and have it at home. So she'd had, authority to do that. But again, the managers jumped to conclusions, disciplinary investigation meeting with no details. So the employer said, well, if you're not going to come to another meeting, then we may make a decision in your absence. Ms. Mesen raised a grievance. That grievance was ignored. However, she did return to work. And when she returned to work, she discovered that her HR duties had been completely removed. She was moved to within the sales team, but also housekeeping, which involved cleaning lavatories. She complained about this. Again, she was ignored, and she resigned, and she claimed constructive unfair dismissal. So remember, constructive unfair dismissal is that claim that individuals can bring when they have the right to be not to be unfairly dismissed under the Employment Rights Act. Yes, there are automatic rights as well that we have to remember, but certainly it's that right not to be unfairly dismissed. So the argument is that whilst the employer has not actually dismissed me, their actions have forced me to assume that they no longer uphold the trust and confidence that holds between myself and them. Therefore, I can no longer work with them, and therefore I resign. So the employer has to justify why they did not, in fact, breach the employment contract. But perhaps unsurprisingly, Bradford Management Services and another were unable to do that. And Ms. Mesen was successful in her claims for deduction of wages, discrimination and harassment on the great basis of maternity and pregnancy as well. So again, you know, a really difficult case, I think, for many of us to reconcile. And Miss Mesen was awarded nearly £30,000 by way of compensation for her injury to feelings, which is that claim that that compensation for discrimination and harassment. And also, interestingly, she received the ACAS uplift. Now, you're probably thinking, what is the ACAS uplift? Well, the ACAS uplift is an increase that claimants can seek to their compensation where the employer has completely failed, either completely or partially, to have complied with the requirements of the ACAS code when dealing with disciplinaries and grievances. So in this case, she raised a grievance, it was ignored. We've got invites to disciplinaries without being told what the nature is, not being able to state your case, etc. So we've got real failures there in terms of the failure to follow the ACAS code. And in this case, her compensation was increased back to 25%, which is why it's incredibly important for managers to understand the importance of following those internal processes, and what we'll be focusing on a lot in the Manager Masterclass. The other point I want to raise here is the and another. Now, often when we think about employment tribunal claims, we're thinking about claims that can be brought against the employer. Well, discrimination and harassment claims are different. Claimants can name individuals, which is exactly what happened in this case. So Ms. Mesen brought a claim not only against the employer, but also against a direct individual as well. So again, we have to remember that personal liability element. And also, you know, many of us in our contracts of employment will have a flexibility clause. So we will have something in there that says, you know, we reserve the right to ask you to undertake other jobs within your level of qualification, or however it may be drafted. And one of the arguments the employer made here in asking or demanding that Miss Mesen move to work in the sales team and obviously in housekeeping was that there was this element of flexibility. And I think we need to distinguish between an employee who occasionally mucks in, which Miss Mesen had done, but being able to unilaterally change someone's job from HR executive to working in housekeeping. You know, that's too big a jump. So again, yes, flexibility is great, but we have to remember where the boundaries of it are. So a really sad case there. And I think some lessons learned, particularly around health and safety obligations to our pregnant ladies, you know, not failing to follow a process, falsely accusing an individual. So again, some really, you know, a difficult set of facts to read. And again, some huge lessons learned there, one would hope. Now, the next case that we are going to look at involves Pilkington, which is a glass company, and Mr. Jones. Now, Mr. Jones had worked for Pilkington for nearly 40 years, 36 years he'd worked there for. He started as an apprentice and he worked his way up to becoming a team leader. Now, Mr. Jones had suffered from cancer. And as a consequence of the cancer treatment, he developed a chronic shoulder injury, shoulder pain, and also developed, because the pain was so debilitating, this impacted upon his mental health as well. And his employer fully knew about, the injury. And he went to see occupational health, and occupational health signed him off and basically said he could return to work once the pain had been stabilized, but he would have to return to work doing non-manual tasks. So again, employer fully aware of the situation, what Mr. Pilkington could and could not do. So Mr. Pilkington went off on sick leave. Now, whilst he was on sick leave, one of his colleagues reported to the employer that Mr. Pilkington had been seen wearing work boots and working on a farm. Now, probably most of us with our HR hat on would be saying, well, you'd give him a call, wouldn't you? You'd contact him and say, look, Mr. Jones, saw you doing this. Are you all right? What's going on? Just to find out what the situation might be. However, the employer in this case didn't do that. What they did was they contacted a local private surveillance company, and they asked him to go and watch what Mr. Pilkington was doing. Now, he was videoed, and that video was then sent to his employer. And the video did show Mr. Jones, indeed, with his work boots on. He was on a farm, and he was lifting bags of potatoes from a truck. He was summoned to a disciplinary meeting, and he was dismissed for gross misconduct without notice, so summarily dismissed, because they said he was undertaking a secondary job whilst he was on sick leave. Now, Mr. Jones explained to them that indeed he was on a farm, but he was on a community farm, and it was part of his therapy. It was part of the treatment that had been prescribed and facilitated by his GP to help him with his mental health illness. So that's why he was at the farm. The employer did not accept that. They dismissed him because they said that he was working. So what happens next? Well, Mr. Pilkington brings claims for breach of contract, unfair dismissal, and also disability discrimination. And his argument is that I've been treated less favourably because I'm disabled, but because of something arising as a consequence from my disability. And Mr. Jones said that something arising was the employer's mistaken belief that I was undertaking paid work whilst I was off on sick leave. And then the employer would have to show that they had a legitimate reason for using that reason to dismiss him. The claimant's claim was successful, and he was indeed found to have been unfairly dismissed, and also to have been treated less favourably because of a reason arising from his disability. We don't know what the compensation is in that case, because the case will be listed for a separate remedy hearing. But again, I think we can see, can't we, that, so many lessons that we could learn from that case. When you've got an individual who's worked with you for, 36 years, it would only be respectful to give them a call and sort of find out what's going on. And I think, diving straight headlong into, disciplinary hearings. And also I would question their investigation. It would have been quite easy to have done some investigation work around, was he indeed working on a community farm as part of prescribed therapy by his GP. So again, beware of jumping to conclusions, and beware of making assumptions as well. So again, a sad case there, I think, but one where, we can certainly take away some learning points. The next case I want to talk about is also a case involving disability discrimination. And in this case, the individual was diagnosed with cancer. Now, I have talked about what the definition of a disability would be under the Equality Act. However, there are certain conditions which would be automatically considered as a disability without the need for symptoms to persist for 12 months or pockets of 12 months. And there are certain cancers that would fall within that classification of an automatic disability. So in this case, Ms. Willis, upon her diagnosis, she would have been classified as having a disability. And once somebody does have a disability, then duty to make reasonable adjustments, obviously to ensure that we're not treating that individual less favourably. Now, this case, Adeline Willis and NatWest, many of you may have heard about it because it was in the news. It made the national press. It made a lot of the kind of financial press because of the amount of money that this individual was seeking to claim, particularly in terms of loss of earnings. So it was one that hit the headlines whilst the case was going on, but also once the compensation was awarded. And what happened here was that Ms. Willis was made redundant from NatWest. So her role was made redundant, and she managed to find a secondment within the organisation. Now, it seems that the secondment that she was successful was based up in Scotland, and she was based in London, and there was some discussion around whether the role would move, but that seems to have sort of been put on hold. And then in the meantime, whilst there were sort of these discussions going on, Miss Willis was diagnosed with colon cancer and told obviously her employer about this because she needed treatment, time off. And then again, things seem to have changed within the relationship. There was a recording made of managers discussing the fact that her role was critical, and again, praising her for her team leadership skills, but basically saying that because of the amount of time she would need to take off work, that they should bring the secondment to an end. So again, not having that supportive conversation, what can we do? How much time do you need? Let's help and support you. No, too much time is going to be had. We need to bring that secondment to an end. So we've got there, obviously, that treating somebody less favourably for a reason arising from their disability. Again, the amount of time that she needed off, quite understandably. She asked for an extension of her secondment to allow for her treatment and as well for her to sort of come back and prove herself in the role, but that was refused. Eventually, the employer did agree to extend the period of secondment. She was given no end of year review, and actually she received the lowest ever bonus from the bank. When she did return from treatment, she was told on a team call that she wasn't needed. Again, not an awful sort of thing to say to somebody in an open meeting. Her secondment was then terminated, and she tried to find alternative employment within the bank. She was unsuccessful, and she was made redundant. So what happened here? Well, she brought claims for unfair dismissal, and as you can see, various claims for disability discrimination, so arising, again, that failure to make reasonable adjustments. And she was awarded £90,000 in compensation because the court held that the actions of her employer were discriminatory and they had been extremely hurtful to her. So we can see there, a large award that's been made. Yes, an element of that would be salary, which would have increased her compensation. So again, employers making assumptions about what individuals can and cannot do. We've got a refusal there to consider extra time off. Again, not much in the judgment about, where HR was in terms of this. So again, the lack of clear communication, the lack of support, the lack of planning that we see when we have individuals that do have those long-term health conditions that need the help and support of their employers. And the consequences are an employee is left and she's brought a claim against the bank, which hit the headlines. So again, that negative press, that negative attention, we want to be that destination employer, and then all of that good work is then, undone because of, steps that should have been taken by leadership and management. So again, a case there where, the employer could have got it right. The next case I want to look at is a little change in direction, but again, it's part of this theme in terms of having those conversations with individuals, again, making sure that our contracts are up to date, and really thinking about how we can use our contracts in a better, more effective, and a business protection way. Now, apologies for the facts of this case, but the individual here, Mr. Boydell, worked for pharmaceutical company NZP, and he worked in their bile derivative section, so a very, very niche area, bile products, and he was one of the managers in there. And he was head of commercial, again, specialty products, niche area. And he was also a shareholder of the business as well. And he told his employer in November 2022 that he was going to resign from his employment. And his employment was due to end on the 25th of January 2023. Now, in his contract of employment, and indeed the shareholder agreement, but we'll focus on the employment contract, he did have what we term post-termination restrictions. Now, those of you who have been on my training courses or listened to me before in webinars, I do talk a lot about how we can use our contracts as business protection tools. And I think we often forget that, yes, our contracts have to cover off all that great stuff, all that great Section 1 information that we have to cover, but also what are we including in there with regards to notice? What are our options? Termination, IP, confidentiality, and restrictive covenants. So restrictive covenants are looking to stop or limit the activities that an individual can undertake after they have left your employment. So not poaching of key employees, not poaching of clients, prospective clients, and in some cases seeking to stop an individual from working for a direct competitor. Now, when we think about restrictive covenants, there has to be a proprietary interest that the employer is legitimately seeking to protect. So we can't just stop people not working. There has to be a legitimate interest that the employer, proprietary interest that the employer is seeking to protect. And then the restriction must be reasonable in terms of its scope, in terms of the geography. So perhaps you've got some sort of jurisdictional limits there, and also in terms of time. So the idea is if you keep these periods as short as possible, where we can, in order to protect that proprietary, that legitimate proprietary interest. Some of you may know that the government courts traditionally don't like restrictive covenants because, it potentially stops people from working. So we've got that sort of policy aspect there. But as we know, the government is seeking to consult on restrictive covenants and looking at how the drafting of them, and in particular, the length of time with which that they can last for. So looking at having a kind of a blanket 3-month restriction. So we'll have to see where we get to with that. However, let's go back to Boydell and NZP. So Mr. Boydell has obviously said that he wants to go and work. And before he leaves, he does tell them that he is going to join a competitor of NZP's. So NZP decides to hit the button and go to the High Court and seek an interim injunction, trying to enforce the terms of not only the contract of employment, but also the shareholder agreement. So within the contract of employment, Mr. Boydell has a 12-month period of restriction, and these restrictions sort of talk about what activities he can and cannot do. In the shareholder agreement, there is a 24-month restrictive period. So the employer here is really kind of hedging their bets in terms of which period of restriction will be enforced, if indeed it is enforced at all. So they go to the High Court The High Court refuses to enforce the shareholder 24-month agreement, but it does agree and does uphold the 12-month restrictive period within the contract of employment, subject to some conditions. So we talk about the judge having their pen and going through and crossing out bits of a clause that it does not like. And in this case, there were some activities that had been listed there. Court didn't like that, so crossed those out. But essentially, the restrictions were allowed to happen. And again, Mr. Boydell trots off to the Court of Appeal. And again, the Court of Appeal says that the employee has such extensive knowledge of NZP's commercial information that it should be protected after his employment. Then the area that he works in is so niche to be considered as vital to protect the employer's legitimate and proprietary interests. Now, also, what was quite clever is that the employer had been very prescriptive and very restrictive in terms of the activities that the employee could and could not do. So they'd listed the activities. And again, that was quite good in terms of it wasn't this sort of, you can't work anywhere ever. So they'd been very kind of narrow. So again, points to remember, please think about your contracts of employment. Are you using them as effectively as you should be? When was the last time you reviewed your contracts and also your policies as well? We're reviewing handbooks, we're reviewing contracts for employers. So again, get in touch if we can help. Restrictive covenants are not suitable for everybody, and I cannot stress that enough. If you put them in everyone's contract of employment, then you're going to dilute their value. So we're really looking at those individuals that work in those senior roles, niche roles, client-facing, access to confidential information. So again, not relevant for everybody. Also, they have to be reasonable at the time they are signed. So we're not crystal ball gazing here. You can't put them in someone's contract as when they start as a junior with the thinking that, well, in 10 years' time, when they're the manager, they'll be enforceable. No, if they're not enforceable at the time that they're given, you can't then say, well, you can't rely on them in the future. So what do we do? Well, we think about reviewing our contracts. We look at making sure that we are looking at contracts when people are being promoted. So what are we doing on promotion? Are we linking some sort of promotion and pay with new contractual terms? What does that look like in terms and consideration? So again, review your contracts and make sure that they work for you. Again, other alternatives could be a longer notice period using garden leave. So again, there are lots of tools within your toolbox. And I think often we forget just how important our contracts of employment are and should be. So again, if you want to talk about contracts, if you want to talk about restrictions, if you've got an issue with somebody who's leaving to go and work for a competitor and unsure about what you can do, then get in touch with me, eO'Connor@boysturner.com. So we've got lots coming up for you. October, I'm going to do a legislation tracker webinar. So what's coming up? We've got lots of things that seem to be in the pipeline that have been passed, but they're not fully in law yet. So what's kind of happening there? So let's do that. November the 23rd, date for your diary is, of course, the Manager Masterclass. So again, please do come along to that. Really excited. Can't wait to see as many of you as I can do on that course. Again, we're going to do a webinar looking at equality and diversity and how we can be that inclusive leader. And in December, I'm going to do a webinar with my immigration colleagues where we look at employment and immigration law. What have you missed and where have you been? So a jam-packed programme for you there as we move to the end of the year. So thank you very much for joining me. Apologies for yesterday and my slide gremlins, but all seems to be working today. So thank you very much for joining. Thank you very much for listening. Again, follow us on social media. Follow us again on LinkedIn as well. So do get in touch. Lots of ways that you can communicate with us. And again, I look forward to seeing you all on our next webinar and again at the Manager Masterclass. Thank you very much indeed.